Good morning, ladies and gentlemen, and welcome to our corporate and finance update on Brexit and the future partnership with the UK. On behalf of all the staff and lawyers at Lydian, I want to wish you a successful and a healthy 2021, with hopefully soon the possibility to see each other in person again rather than on screen. My name is Maxime Kolle. I'm a partner in the corporate and finance department at Lydian, focusing mainly on M&A and company law. And together with my banking and finance partner, Tom Geusens, we will take you through a 45-minute dive on the corporate and finance impact of Brexit. Some housekeeping rules to start. On your right-hand side, you will see the possibility on their handouts to print or download the slides. You will notice that the slides are a bit more elaborate than what we will cover in this webinar. This is to give the opportunity to people that would have the willingness to dive a bit deeper after this webinar. There will be a poll question. In any event, everyone that participates in the webinar will receive a certificate by GoToWebinar. Those of you who answer the poll question, rest assured it's not difficult, will receive a certificate by Lydian certifying active participation. There's also the possibility to ask questions through the chat function. Due to time restraints, Tom and I will not answer those during the webinar, but we will send you an email afterwards. So let's have a look at what Brexit means from a corporate law perspective. First, as an introduction, the state of affairs. As you all know, the UK became a third country on the 1st of February 2020. There was a transition period in place during which the EU law was still applicable in the UK, but that transition period ended the 1st of January 2021, meaning that both de jure and de facto the UK is no longer an EU or an European Economic Area member state, and therefore EU law will no longer apply in the UK. As you know, in November 2019, the basic elements of the separation, or the divorce, if you will, between the UK and the EU was let down in the withdrawal agreement. But luckily, the day before Christmas, there was an agreement reached between the EU and the UK on trade and cooperation, the so-called TCA. The TCA has already been approved by the British Parliament. The European Parliament will approve it probably before the 28th of February 2021, but it already applies on a provisional basis. For your reference, in addition to the TCA, there was also a EU-UK Security of Information Agreement and a EU-UK Civil Nuclear Agreement. Now, what's next? For those of you that took the time to flip through the TCA, it's about 1,200 pages thick. A lot has been included in the TCA, and it's quite an achievement that with the deadline in sight, parties reached an agreement, which is very positive. But of course, it is only a framework agreement. A lot will have to be decided still politically in technical committees and so on. So what's next? Well, the coming months and years will be very interesting, not only from a corporate and finance law perspective, but more in general. So what does this mean for company law? Let's first have a look at the status of an UK company in Belgium or a Belgian company in the UK. The principle is laid down in Article 54 of the Treaty on the Functioning of the European Union, which basically ensures the recognition throughout the EU of a company that was incorporated in one of the member states. That means that for third country companies, there is no automatic recognition, and as of the 1st of January 2021, the UK is a third company. So that means that legal personality and limited liability of UK companies that have their central administration principal place of business in Belgium will no longer be automatically recognized. For Belgium, we will see in the next slide, this is not really an issue. For real seat doctrines, countries that can be an issue. So recognition will now be based on national private international law or treaties, which are at this stage not in place. And the biggest issue for a UK company is, of course, that the legal personality that that without legal personality, the shareholders may be held personally liable for the company's debts if local law would view a company not as a company, but for instance, as a partnership. The Belgian legislator anticipated when it reworked the Belgian Code for Companies and Associations in 2019, the fact that things could change in respect of Brexit, and it replaced the so-called real seat doctrine by the incorporation doctrine. In short, the real seat doctrine looks at the company and applies the law where its principal business is located, whereas the incorporation doctrine looks at the company and only where it is incorporated, which makes it much easier. You don't have any discussions on where the principal business of a company is. So that means that as of the 30th of April 2019, in Belgium, the law applicable to a company will be the law of the country where that company was incorporated. And in fact, the principal place of business is no longer relevant. So concluding on this point, Belgian law still recognizes companies incorporated in the UK and vice versa. If we look across the channel, also the UK applies the incorporation doctrine. So also Belgian companies will be recognized in the UK. Of course, this is company law and not tax law. And as Brad Pitt learned us in one of his movies, there's only two certainties in life, debt and taxes. And whenever you have a structure since the 1st of January 2021 with a UK component in it, tax law will become much more important than we were used to. So we've looked at the status of a company. Let's now have a look at the status of a branch of a UK company in Belgium, or a branch of a Belgian company in the UK. In Belgium, branches of companies incorporated in an EU member state will benefit from less onerous registration, filing and disclosure requirements. The UK has become a third country, so there will be more stringent registration, filing and disclosure requirements for Belgian branches of a UK company. And again, if we look across the channel, the same will apply for for UK branches of Belgian companies. The next slide is maybe less important, but I still wanted to share it to you. Brexit also has some relatively less important consequences, but still from a practical point of view, things that are worth mentioning. There was a so-called BRIS, Business Register Interconnection System, that was fed through the different company registers throughout the Union, and which was accessible to the European e-Justice portal, which made it for us practitioners very easy to get a quick overview on companies outside of Belgium. This will, of course, no longer be fed by the UK company register, so that will be a bit more complicated in the future. And of course, if you're a Belgian director of a UK company, you will have to fulfill a number of additional information formalities, which was not the case before Brexit. EU company forms. The EU, through company law directives, have implemented three major forms: the European company, the SE, the European cooperative company, the SCE, and the European economic interest grouping. Basically, an SE was implemented to promote cross-border business throughout the Union, and made it easy to set up holding structures through an SE, and also allowing, which we will see in a couple of slides, cross-border mergers in a relatively easy way. Now, an SE must have its registered office in an EU member state, and its head office should be in that same member state. And therefore, as of the 1st of January of this year, an SE having its registered office in the UK will have lost its SE status, but luckily UK law anticipated and provided for an automatic conversion into so-called UK societas for those who didn't make the necessary arrangements in time. Basically, it's a temporary form allowing people to reorganize themselves, and we anticipate that a lot of these UK societas will later transform into an LTD. Again, it doesn't mean that because of losing the SE status that you cannot be recognized in EU member states, and we've seen that in the first couple of slides. And of course, since the 1st of January of this year, it is not possible for a UK company or entity to participate in the formation of an SE. European economic interest groupings are a form of association consisting only of companies or other legal bodies formed in an EU member state with their registered or statutory office and central administration in the EU, or of natural persons carrying out services in the EU. Again, their status will be lost for UK EEIGs as of the 1st of January, but the UK legislator provided for a similar automatic conversion into the UK form, allowing, again, partners a bit more time to reorganize. Another consequence is, of course, that where a UK incorporated company or another UK legal body was a member of an EEIG, and where natural persons would carry only out services in the UK, they will automatically cease to belong or to be a member of the EEIG after the end of the transition period. Now, some highlights for listed companies, and the impact the next couple of years on listed companies will probably be rather important. As of today, it was much easier when you're dealing with capital market transactions to set up transactions throughout the European Union than, for instance, with that other large market in the US, NYSE or NASDAQ. Those advantages will unfortunately over time disappear because we anticipate that right now there is still a lot of similar legislation in force in the UK, but it can be anticipated and feared that over the next couple of years there will be a divergence in the way people view capital markets transactions. So maybe on the prospectus regulation, the possibility to passport a prospectus approved by, for instance, the FSMA into the UK will disappear, and vice versa. The possibility to passport a prospectus approved by the FCE into Belgium will disappear. So without equivalence decisions, which are not yet in place, you will have to make sure that you register your prospectus with the right regulator. So for Belgium, that means that issuers will need to have a prospectus approved in an EU member state if they want to list in Brussels. Fortunately, an issuer that is already admitted to trading in an EU regulated market based on a prospectus that has been approved by the FCA and that was passported in Belgium will not have to reapply for admission to trading, which would be very burdensome. Maybe a small tip on agreements and documents. Do check references to EU regulated markets and take into account, of course, that the UK regulated market is no longer part of that definition. On the next slide, I've briefly highlighted a number of other instruments that do no longer apply in the UK, the Shareholders' Rights Directive, the Transparency Directive, the Market Abuse Regulation, and the Takeover Bids Directive. I will not go into detail on them, but as mentioned, in the future, it is possible that shareholders' rights will not be the same in the UK as it is the case on the continent. Which of course for an investor makes it a bit more complicated. What are the thresholds to convene a general meeting? How can you exercise your voting rights, and so on and so forth. Transparency, today the same thresholds still apply in the UK at 3%, 5% and multiples, but who knows what will happen in the future. The market abuse regulation, kind of interesting, has ceased to apply, but the UK adopted an instrument, the UK MAR, which is 99% the same, and we will see in a couple of slides a little bit more information on takeover bids. So with respect to M&A, the message that I want to start out with is keep calm and carry on. And why? Because M&A transactions are governed by private contracts, which is a civil law matter. And so in the end, there will not be a lot of changes. However, there will be some impact. The cross-merger directive, which basically applies to companies governed by the national laws of EU member states, will no longer be of effect in the UK, which means that whenever you have a UK component, the EU cross-border merger regime cannot be used anymore and will disappear. Belgian company law provides the possibility also outside the EU to apply the same cross-border merger regime, but only if the relevant company allows that as well, and that is not the case for the UK. So that is a bit unfortunate, and maybe in the future that will change, which would make restructurings with the UK much easier, because right now without the cross-border regime, in principle restructurings with the UK company will become more burdensome, and there will be, from a legal process and administrative perspective, more formalities, which means more time and more costs for the companies involved. So how we will tackle this? Well, probably the first step, we will set up a share deal or an asset deal, and then followed by the dissolution or the liquidation of the transferring company when it is no longer needed. But as you know, the more steps you add to a process, the more complicated it becomes. Takeover bids, the takeover bid directive does no longer apply, and therefore the rules where all or some of the securities are traded on a regulated market will no longer apply in the UK. Which means that you will each time have to look at the national rules. And it's not only the rules that will change, but also the regulators, because the UK Takeover Code was amended and no longer applies to takeover bids that would otherwise have been subject to the so-called shared jurisdiction regime. As mentioned before, that will lead to less harmonization, not only from a regime perspective, but also from a regulatory perspective. Which is a bit unfortunate, but okay, we have the experience when we do multiple listings or issuances on NASDAQ and NYSE, which will now lead a bit the example for the UK as well. 2 words on merger control. One of the cornerstones of the TCA is to create a level playing field with the UK. And of course, what the EU wants to avoid is that the bar for competition law would be lowered by the UK, and that therefore there would be unfair competition with our internal market. And so competition, the parties should maintain a competition law which effectively addresses a number of anti-competitive business practices. And it's also the end of the so-called one-stop shop principle. Before the end of the transition period, when you had a transaction with the UK company involved, you could opt to only notify the European Union Competition Authority, and its ruling would be valid for all the EU countries involved. That will no longer be the case. So you will, whenever you have UK component, end up with parallel proceedings. Now that was the theory. Maybe some practical tips when drafting, negotiating, or revisiting contracts, because it's not only new contracts. A lot of people will need to take the time to revisit existing contracts and see what should be amended. It starts, of course, with due diligence. What does Brexit will have as an impact on the target company or on its business? We will have to look at purchase price adjustment mechanisms, and because we still don't know the exact impact of Brexit. It's unlikely that MAC clauses will be triggered, but so parties should reflect on the necessity to have specific Brexit clauses, for instance, additional termination rights. Compliance will change, and not only from a material law perspective, but also from a pure terminology perspective, meaning that the EU and EU regulators will no longer include the UK. Territorial scope, I give one example, a non-competition clause, which, as we know, should be limited in time, in geographic area and in activities. Well, the geographic area a number of times is the EU. So if you want to have the UK in scope, that will be an important thing to note when drafting contracts. And finally, dispute resolution and jurisdiction of courts, choice of law and execution of judgments. The EU instruments will not apply to the UK anymore. For governing law, that's not really an issue. You can still choose the law you wish, Execution, you will need a Belgian judgment rendering exequatur to a UK judgment, which will make it a bit more complicated. And the jurisdiction, of course, is well, pretty complicated at this stage. I refer to the webinar by my colleagues Yves Lenders and Jo Willems on that topic. So in general, to conclude from a corporate law perspective, the impact of Brexit is not earth-shattering, and there will be a bit more red tape that can be expected the next couple of months, and we will have to monitor the impact and, of course, the long series of additional legal changes that will follow, no doubt, the next months and years. As mentioned, don't forget tax in the whole equation. To give but two examples, tax-neutral mergers will no longer be possible with a UK company, but also the fact that when you sell as a natural Belgian person a material interest in your company to a company or a person in the EU, you can do that on a capital gains tax-free basis. That will also no longer be the case if you sell that interest to a UK person or a UK company. Of course, this is not dramatic. You can just simply set up a subsidiary in Belgium as a BitCo, but it's things that in practice we should take into account. Of course, in M&A, be careful. Look at the applicable law, references to regulations, data protection, consumer protection, and so on. And maybe the most important message from my part is, do not rely entirely or solely on your pre-Brexit templates and models. Be critical for yourself, for your co-workers, and if necessary, seek specialist advice. To finish off, from my perspective, a short poll question. Has the status of a Belgian branch of a UK incorporated company changed as of the 1st of January 2021? First possibility, no. The TCA does not contain specific provisions on branches. Second option, yes. More stringent filing and disclosure requirements will apply. And the third possibility, yes, a Belgian branch of a UK company is no longer possible. So I will open the poll now, and you will have 30 minutes to choose your answer. Thank you. Thank you. I'm very glad that most of you answered that question correctly, and I will be happy to now give the floor to Tom.
Well, thank you, Maxime. We're dealing now with financial services, financial institutions, and Brexit. When looking, perhaps to begin with, on the 3rd of November 2019, there was a quite interesting quote from Boris Johnson. He mentioned that we've got an oven-ready deal. Put it in at gas mark 4 and give it 20 minutes. So that was on the 3rd of November 2019. It took him not 20 minutes, but it took him like 1 year and 2 months in order to end up with a Brexit deal by the end of December 2020. A Brexit deal, as Maxime mentioned, which is a framework agreement, and which is not more than that, because when you look at the Brexit deal in more detail, and when you go and look for financial services, financial institutions, how is it dealt with, then it's quite silent on that. Although last time I remembered, and it is already quite some time, given the circumstances these days, last time when I flew into City Airport London, when setting in the descent, you see these nice big buildings of Barclays, Citibank, HSBC. So they have quite some financial services, so I'm told, in London, but the Brexit deal is quite silent on it. So why? We'll look into that. When you look to the overview slide, you see that we'll look into the Brexit deal and what it says about financial services. We will then switch over to the Belgian Brexit law and see whether the Belgian Brexit law has certain solutions for financial services providing from the UK into Belgium and vice versa. If that is not sufficient, we will look into other alternatives, such as equivalence approvals. We will look into the national light regimes in Belgium, which mainly focus on MiFID services and alternative investment funds. We will look into reverse solicitation, which is also a possibility for a UK financial services provider to provide its services, provides between brackets, its services into Belgium. And we will finish up with the fancy word of UK back branching. But first of all, the Brexit deal. As mentioned by Maxime, the Brexit deal is basically a framework agreement. It is clear on one point: it does not provide access to UK financial services providers to the European Union. So it does not provide access. It only set out certain principles which state that the UK and the EU agree that one may not impose limitations on the number of enterprises which may provide specific activities in the UK or in the European Union. It states very generally that service providers do not need to be resident in UK or in the European Union to provide cross-border services. However, they have, and on that one they are clear, they have reserved the right to implement certain measures, as well in the UK as in the US, for the need of a local presence in order to provide financial services. So for financial services, they still have this stick behind the door to make it necessary to have a local presence in the UK or in the European Union. When you look at some further general principles, they provide on the next slide that financial service suppliers, they need to have access to clearing systems, to payment systems. They need to have access to funding in order to do the normal business. It may be so that UK or the European Union may implement additional prudential measures in order to ensure the stability of the financial system of the UK or of the EU. So you hear all very general principles which are quite obvious and which still need to be implemented in further agreements. And on that point, it will be quite interesting to look at March 2021, because that is the deadline where the UK and the European Union have agreed to set up a cooperation agreement which intends to establish a structured regulatory cooperation system on financial services, again to preserve the financial stability in the UK and in the European Union, and in order to protect the rights of investors and of consumers. So it's looking forward to that cooperation agreement, whether that will be in place soon. So that being said, the Brexit deal is a framework agreement, so nothing much in it that provides to-date specific regulations in respect to financial services. So then let's look into the Belgian Brexit law, whether that provides certain solutions. And yes, at first sight, the Belgian Brexit law is in force since the 1st of January 2021. And when being in Teams meetings with the UK financial services providers, I'm always happy to say to them that yes, we have in place a framework agreement which provides for a transitional period of 12 months, in which you as a UK financial services provider may still, and you have lost your European passport because of Brexit, you may still provide during this transitional period your financial services within Belgium, provided that you're authorized to do so in the UK. You intend only to provide these services to non-consumers, and you have initiated your process in order to obtain a license, or you have initiated your registration process with the Belgian regulator. That is all nice. However, although it entered into force as of the 1st of January 2021, it is not into force. Why? Because there are no royal decrees implementing this law. The law requires that the specifics of the framework is implemented by royal decrees, and apparently the financial industry is not, they are having difficulties to find an agreement on how to implement this. What does it mean that you must have initiated your licensing or registration procedure? On these points, the financial industry is apparently not on one line. So you do not have a Belgian, you have a Belgian Brexit law, but it has no force basically because of a lack of these Belgian royal decrees. So how can UK service providers then enter the Belgian market? You have three regimes which may be of interest. First of all, equivalence. Secondly, the light regimes which we have in our Belgian national legislation. And thirdly, the reverse solicitation. Firstly, let's look into the equivalence decisions. Equivalence basically means that it's the idea that a third country, such as the UK, has a regulatory, supervisory, and enforcement regime in place which is deemed to be equivalent to the corresponding EU framework. If that is the case, and if the European Union decides that that is the case, they may grant you access to the European single market. And when you look to the European legislation framework, it is mainly drafted into two sets of legislations: the MiFID legislation for MiFID services and the Alternative Investment Fund legislation. Also, CRR provides certain equivalence provisions into it, but I believe for the financial services providers in the UK, the MiFID and the AIF regulation is the most important one. However, there are no equivalent decisions to date, not relating to these financial services. There is one equivalent decision to date relating to UK central counterparties on the next slide, who now have access to the European Union, but that is the only equivalence decision to date. So then you have to look to the other exceptions, the national light regimes. In Belgian legislation, you mainly have two sets of regulations, again, that have these national light regimes for UK financial services providers that do not have a license in Belgium or have no physical presence in Belgium. And again, that is the MiFID regulation and the Alternative Investment Fund regulation. When you firstly look into the MiFID regulations, it provides that UK investment firms, they may provide their services into Belgium to professional clients and eligible counterparties, provided without having an establishment in Belgium, provided that Belgian investment firms can do the same in the UK, and provided that you have notified the Belgian regulator, the FSMA, of your intention to provide these services, these MiFID services in Belgium. Of course, you will have to comply with Belgian conduct of business rules, which is not that problematic. So it's a quite interesting light regime. Perhaps important to note is that alternative investment fund managers with MiFID top-up permissions, such as portfolio management, investment advice, receive, transmit orders, etc., we do not believe that they can benefit from this light regime for the mere reason that that they are not investment firms. They are a fund, an alternative investment fund, and they are not an investment firm that provides these MiFID services. And an AIF cannot be recognized or cannot apply for an investment firm permit. So AIFs with top-up permissions cannot benefit from this light regime in respect of the top-up permissions MiFID related. That's for the MiFID light regime. When you then look into the AIFMD light regime, you see that non-EU fund managers can market EU funds and non-EU funds into Belgium EU fund managers can market non-EU funds into Belgium, again, provided that they have notified the Belgian regulator upfront, and provided that it is not a public offer, so that the fund offering is done under the private placement regime. If it is a public fund, again, you will have to register beforehand with the Belgian regulator. Another interesting question is what with UK UCITS after Brexit? UK UCITS after Brexit, the UK is a third party, so UK UCITS after Brexit, they automatically will be regarded as third country alternative investment funds. They can still be marketed in Belgium, provided that you've notified the FSMA on beforehand, and provided that it is done under the private placement regime, so that it does not qualify as a public offer. Otherwise, again, it will need to be registered in Belgium. Important to notice that the management companies, they will need to do the necessary in order to inform their investors that they are now regarded as third country alternative investment funds, and that means that it has certain consequences for the investors themselves. Reverse solicitation. Reverse solicitation is another means, is another way that UK financial service providers can enter the Belgian market. What does it mean, basically, reverse solicitation? Sorry. What does it mean? Basically, it means that the financial service provider does not contact you, but that you, as an investor, contact the financial service provider. If it were only that simple, of course, in practice. When looking to reverse solicitation, you will have to look into the question, where is the financial service provided? Is it provided in Belgium or in the UK? And when looking at that question, you have two tests which can lead to the fact that the financial service is provided either in Belgium or in the UK. You have the characteristic performance test and the solicitation test. The characteristic performance test basically means that where is the service provided? Where is the location that the service is provided? The solicitation test means, are clients solicited in Belgium or not? And if one of these two questions points to Belgium, you may have licensing requirements in Belgium if you cannot rely on equivalence, light regimes, or other exceptions. The legal basis for the reverse solicitation lies again in the two sets of legislations, which we've already dealt with in this presentation. It lies in the MiFID and in the AIFMD regulation. When looking from a practical point of view on the next slide, you will first look whether the performance of the service is done in the UK. Then secondly, you will look into the fact whether or not promotion marketing has been done in Belgium. And you will also look to the website of the financial institution, and you will look to the fact whether they specifically target Belgian clients or not. If this is all answered by no, you can base yourself on reverse solicitation. However, quite clear, if for some reason the fund or the manager has already provided fund documentation to Belgian clients, you can no longer rely on reverse solicitation. Reverse solicitation is a topic which has been much discussed, also on EU level. There's much to say about reverse solicitation, but the takeaway from reverse solicitation must be that if you rely on reverse solicitation, you must do that with extreme caution. Last topic to deal with and to round up the financial services presentation, and I believe that we will end up nicely within the setup timing, is the fancy term UK back branching. UK back branching basically refers to the discussion which boils down to all the big French credit institutions, the German credit institutions, which have their financial services centers in their branches in London. What can they still do through the branches? Can they still provide these financial services through the London branch or not? The ECB and ESMA has provided a lot of guidance in this respect, in respect to what is possible or not. But I believe on the next slide, what we've seen in practice is that you must look to this UK back branching from a chaperoning point of view, meaning that the European staff must at all time chaperone the London staff. What does this mean? What that does mean in practice, basically? That means that the European staff must have an oversight and that they must monitor the London staff in respect to each communication which they do with their clients. They must accept responsibility and they must have authority over the London staff at all time, preferably the European staff must expressly approve the actions which the London staff perform in respect to this back branching financial servicing, which is provided by the London staff. It basically boils down to what is the seniority of the European staff over the London staff, which authority does the European staff have over the London staff in respect to contact with clients, in respect to communication with clients, in respect to contracting with clients. It may not be a contracting from the London branch, it must be a contracting from Paris or from Frankfurt. So basically, it must be a European service and it may never be a London service which is provided to the client. So this basically rounds off the presentation on financial services. I believe that it will be interesting to see the coming weeks, the coming months, how far the negotiations will go with respect to the cooperation agreement between the European Union and the UK in respect to financial services. March 2021 will be an interesting time to see whether or not they will make this deadline or whether they will postpone again the deadline as was previously done. And then the question, of course, remains, what will the Belgian legislature do? Will they come up with a royal decrees under the Belgian Brexit law, or and will they provide in that respect clarity to UK financial service providers? Because to date, they're still working in the dark and it's not clear exactly how they have to operate into Belgium, their financial services. So thank you very much. I hope that you have enjoyed the seminar. Any questions which have popped in the chat box will be dealt with after the seminar, and we will email you with our responses to all your questions. If you have any questions which have not been popped up in the chat box, do not hesitate to contact either Maxime or myself, and we would be happy to help you out with these questions going forward. Let me say that you can round off to visit our Lydian website and check in when and where our webinar seminars are being organized. I believe there's still one Brexit webinar that comes up this week or next week. And other than that, there are quite some webinar initiatives from Lydian, so please feel free to register for these webinars. And as for now, there's nothing more to say than stay safe, stay healthy, and take care of yourself and of your belongings. Many thanks. Thank you.
Indeed, many thanks. Have a nice day.